Welcome back. A reminder of breaking news this evening. The National Assembly has voted to proceed with an inquiry into the Public Protector's fitness to hold office. The governing African National Congress had earlier instructed its parliamentary caucus to support a motion in favor of an inquiry into the Public Protector Usisiwe Mkhwebane's fitness to hold office. Some of its officials, including Party Chair Gwede Mantashe and Treasury General Paul Mashatile, addressed the caucus in an emergency meeting ahead of Tuesday's sitting. As you heard from my colleague Abel Babia earlier on, that there was an overwhelming vote in support of an inquiry. Nthabiseng Dubazana is Director and Attorney at Dubazana Attorneys. A very good evening to you and thank you so much for joining us, Nthabiseng. So let's look at the importance and the significance of this parliamentary process. How will it define the respect of the Constitution and the rule of law?
Thank you for having me. Well, I think it is significant in that the way the Constitution was developed when it was first introduced in the country in 1996, it was that there's going to be a concept of separation of powers, right? And with those separation of powers, there's going to be checks and balances on each sphere of government. So there's no intrusion per se on each sphere of government, but we need to make sure that each sphere of government is accountable in how they work in their mandate. So this decision that there's an inquiry that's going to be held, I think it works into that and shows the flexibility and the intention that was behind such a principle of separation of powers. So now we have a situation whereby indeed the National Assembly has the right to have inquiries such as the one that they're going to have into the fitness of the person who's holding the office of the Public Protector. So now at this stage, what we're going to see, or hopefully going to see, is that once that inquiry is done, it will probably change in the terms, so to speak, of how such a person who holds such an office would now be interviewed. The specific case.
So let me just interrupt you on just that point, because that's what I find interesting. A lot of people have said this matter has been politicized, and in fact the Public Protector herself has been accused of politicizing certain legal decisions, in the sense that she has been found to take decisions that are believed to be outside of her purview. Now, the accusation cuts both ways, as I say. I want to talk about whether or not is it inherent within such a position as a Public Protector. Obviously, there's got to be the separation of powers, as you say, but is it inherent that it will always run up against this accusations of politicization, or the office itself being weaponized for political battles?
Look, I think it's unavoidable because now her office is the heading of the institution itself is self-explanatory. It's a Public Protector. So if somebody comes from the public and complains about a sphere of government, then she has to, serve the public, or the person holding that office has to serve the public in that manner. That might lead to encroaching onto certain spheres of government, which includes political organizations. For example, Section 5 of the Public Protectors Act says that neither member of the office shall any member of the office of the Public Protector shall be liable in respect of anything reflected in any report, finding, point of view, or recommendation made in good faith and submitted to Parliament. So if on her findings and her investigations, in good faith, she feels that after she has done this and that was required of her by a member of the public, and then she sets it out there as a report, and then it ends up being politicized in the same way it has been happening now. If the office feels attacked, then they also have the right to protect themselves. So like you said, it does go both ways. But at this stage, when you read the recommendations that have been done, she has been found, it's been found that there's a prima facie case of incompetence and misconduct or gross negligence on her part, based on various court cases that she has lost in one form or another.
And just further on those charges, that also includes 3 counts of perjury for lying in court in a legal review application on the Absa Bank Core report about her meetings with former President Jacob Zuma. Now, you talk about good faith, which is unfortunately something intangible that, you know, I can judge it as not being in good faith. She can judge it as being in good faith. So you spoke about the impact of this process and what it will have for future contenders for the position, including herself, if she does continue. Will there then be more hard line terms of reference for the conduct of a public protector?
Most likely, I foresee that to probably be the case, because right now it is just basically things like you have to have either been a sitting judge, or you have 10 years experience as an advocate or an attorney who's admitted, of course, and all such things, and have a knowledge of the law, basically. You know, from the findings that have been leveraged against her, it is alleged that there's a prima facie case that she basically has no basic knowledge of the law. So I don't know how they would go about trying to test a person's basic knowledge of the law and see if their understanding and application and interpretation of the law would be something that a person who holds that kind of office should have. So, but I foresee that to be a possible change and a possible amendment to the Public Protector Act as well, in terms of the appointment of a person who would hold such an office.
No, the Public Protector herself has said she's confident that she'll be cleared of alleged wrongdoing, and has even flagged that there's still a court process underway. What is the importance of this, the significance of this, against the backdrop of an inquiry into her fitness to hold office in Parliament? Those separation of powers, will they then become even more important and applicable here?
I think I missed what you asked, the significance of what?
So I'm saying the significance of that, the fact that there's still a court process underway, will that underline the separation of powers as highlighted by you? There's on one hand a parliamentary process, and there's on the other hand there's a court process. Will they overlap? Will they?
All right, I'm with you now. So what I would suggest or put across would be that while the inquiry is being held, in her position, I would probably request that the outcome, or the start of the inquiry, be held back until the outcome of the court application that she's dealing with. Perhaps it would add or help her in terms of the inquiry being shifted or even eliminated completely. Because now in the report that has been found as well, it is said that had she submitted things like heads of argument or reasons or affidavits as to how she would counter all the cases that are put before the committee that say that she's incompetent and etc., that she didn't do any of that. So perhaps that case that she's now speaking of would probably answer the questions that the committee had. So that would be my step, that could I request that the inquiry be held back for a certain time until my hearing is done and we hear the judgment of that case, just in case it will impact how the inquiry could go or should not go at all.
Now, we know that certain parties and individuals within the governing party were against going ahead with this inquiry to begin with. Is there a way that they can mount an indirect challenge legally or scupper the process?
Well, I think the first thing would be to deal with it.
Unfortunately, we have lost Nthabiseng Dubazana, who is Director and Attorney at Dubazana Attorneys. Such a pity that at that point. But coming up later, we'll also speak to Amnesty International South African campaigner Jennifer Wells on the SABC's crowd control tactics.